I would like to thank the faculty who brought me here and Eastern Kentucky University. It's a beautiful part of the world rich in tradition. And it's really been a pleasure to meet all of you here. I'm going to talk about extreme sentencing of kids and the juvenile death penalty because, as Gary told you, I think the question of the situation of children in the United States today is emblematic of the crisis that I see us in. The great poet laureate of Illinois, Gwendolyn Brooks. Do any of you know Gwendolyn Brooks? Have you read her poetry? Put this down as your summer reading because Gwendolyn Brooks is an extraordinary poet. She died a few years ago, but she was the poet laureate of Illinois. You know who she is. For a long period of time and writes magnificently about ordinary people's lives. And Gwendolyn Brooks once wrote a fragment that says, "What shall I give my children who are poor, who are adjudged the least wise of the land?" And I think that always stays in my mind, adjudged the least wise of the land, as emblematic of the oxymoron that we call our juvenile justice system today. How many of you have ever walked into a juvenile court? I'm not asking in what capacity, but just walked into a juvenile court in one way or another. Okay, so some numbers of you. I think that you will see in juvenile court two systems of justice in America. In the United States, if you walk into the juvenile court of Cook County, which is the world's first juvenile court, you will see 94% kids of color. You would think that white kids did not exist in Chicago or that white kids never broke the law if you walked into the juvenile court of Cook County. It's an astonishing situation there. And so you ask yourself, what takes place here? How does the law work in this situation? Who's getting arrested, stopped by police, petitioned to court, and dragged into the beginning of what we now call the schoolhouse to jailhouse track, right? The kind of greased slide out of the possibility of economic independence, of academic performance, and of a hopeful future. And we once had a pro bono, we try to get a lot of volunteer lawyers into juvenile court in Chicago as part of our project. And I sat once in juvenile court with a volunteer lawyer from one of the big law firms waiting for him to select a case. And he leaned over at one point and whispered to me, "Where is the white juvenile court?" And of course, there isn't one in Chicago. So you have to ask yourself, what's going on here? How do we do that? And there's a couple of possible answers, which I hope we come back to at the end of this talk. I'm going to take a particular strategy that we used to abolish the juvenile death penalty, and about which we were successful 2.5 years ago in the case of Roper versus Simmons, and talk to you a little bit about how we did it and what we did and what the consequences of it now are for framing and organizing and mobilizing a couple of other challenges around the issue of how justice for children is done. So that's my plan. For 6 years, a small coalition of juvenile justice advocates worked to abolish the legal execution of juvenile defenders in the United States. This coalition was inspired by the work of Professor Victor Stribe, who worked for and wrote about the juvenile death penalty almost alone. This is worth noting, that some people and an academic who does this work kind of seemingly alone all of his life suddenly gets joined by a movement and a social force that changes history. He ran a website and did research and wrote about the juvenile death penalty for almost 30 years. By 2005, the coalition had grown to include a whole group of national not-for-profit organizations, professional associations such as the American Psychiatric Association, the American Academy of Pediatrics, the American Psychological Association, the American Bar Association, the Child Welfare League of America, Parent-Teacher Association, and then a whole group of international organizations, Nobel Prize recipients from around the world, who contributed to a strategy that ended what 4 Supreme Court justices called this relic of the past, this shameful practice. On March 1st, 2005, 2.5 years ago, the U.S. Supreme Court abolished the use of the juvenile death penalty in the United States in a case called Roper versus Simmons, which I commend to your attention, holding that evolving standards of decency under the Eighth Amendment provide sufficient evidence that the practice violates the Eighth Amendment's prohibition against cruel and unusual punishment. That day, 72 people who had been arrested as juvenile offenders, the majority of them African American and Latino men, were released from death row and incarcerated in a different prison under life sentences. I'm going to quote a little bit from this because, Supreme Court isn't necessarily the institution I look to for guidance, but in this case, we had ended up with an extraordinary decision. This is the court's majority decision. In sum, it is fair to say that the U.S. now stands alone in a world that has turned its face against the juvenile death penalty. The opinion of the world community, while not controlling our outcome, does provide respected and significant confirmation for our own conclusions. This recognition of international law and its impact on domestic law is, I think, one piece that I'm not going to follow through today, but is a piece that interests me greatly. And I'm spending my latest article is about how we can use international law in juvenile justice today, so we could talk about that afterward if you're interested. But the principal holding of the Roper case, other than abolishing the death penalty, the underlying holding is that children, people under the age of 18, are less culpable. In fact, the Supreme Court says categorically less culpable than adults, less blameworthy, not as morally reprehensible. So here's some quotes. Today, our society views juveniles as categorically less culpable than the average criminal. Juvenile offenders cannot with reliability be classified among the worst offenders. Adolescent behavior is impetuous, ill-considered actions and decisions. Adolescents are overrepresented in every category of reckless behavior. So you have here's another quote from them, the differences between juvenile and adult offenders are too marked and well understood to risk allowing a youthful person to receive the death penalty despite insufficient culpability. So it is valuable to remember in this framework that Christopher Simmons, like all of the 72 juvenile offenders who were on death row when this case was argued, involved a murder which was exceedingly brutal and calculated. Chris Simmons was a white boy in Missouri, a white lad who plotted with two younger friends, so we can't argue that he was seduced by adult offenders, which is the case for many of these juvenile murder cases. He recruited two younger friends. He broke into the home of an older woman, Shirley Crook, whose husband was away that night. They used duct tape to cover her hands and mouth, tie her hands and feet with electrical wire, threw her in the back of their car, drove to a state park, and threw her off the bridge, drowning her in the waters below. So this is not a murder, that there's much you can say about, except it was a heinous crime carried out over a period of time, not just a one-shot, scared shooting. The next day, Simmons went to school and bragged about the killing. So this is the case that arrives at the Supreme Court. It wasn't the case we hoped that would be the first one to challenge the juvenile execution of children in the United States. Nonetheless, with this case, the court notes three general